Hello, I'm Zach Herschensohn. I am an attorney in Kent, Washington. My law firm, Herschensohn Law, is primarily located here in Kent, Washington, but we have two other locations, one in Graham, Washington, and the other one in Ellensburg, Washington. Our office focuses solely on plaintiffs' personal injury claims and cases. The greater proportion of the cases that we handle are auto accidents, but we have both historically and presently done all manner of different types of personal injury practice. So that would include Maritime Jones Act injuries, slip and fall injuries, FELA rail related injuries, medical negligence, PTSD claims. So today I am going to be speaking on a topic that I hope is going to be interesting both to attorneys and also to the general public. So the topic that I will be discussing today is spoliation. And spoliation is defined both in Black's Law Dictionary, which is a legal dictionary, and in the conventional Merriam-Webster's dictionary as the intentional destruction of evidence. So that's the definition of spoliation. And what I'm going to be discussing today and focus primarily on Washington State is what is spoliation legally and what are the consequences of spoliation to litigation. It's a concept that has some concept and the legal consequences of the concept have is such that both lay people and attorneys should be able to take advantage in one way or another of this information. So, spoliation, as discussed, is the intentional destruction of evidence, and it is the duty of every litigant to ensure that evidence is preserved. And the duty to preserve evidence attaches when a party reasonably anticipates litigation. So that's the rule. A party has a general duty to preserve evidence on the eve of litigation. So what this means is that we have to say, well, what is the eve of litigation? The eve of litigation is at any point where a party could reasonably anticipate that there would be litigation. Then the question would be, what are the remedies for spoliation? So let's talk a little bit about what might constitute reasonable anticipation that litigation will occur. One, and this would be the best way to ensure that an adverse party is aware that litigation may occur, is that if there's been an accident or, for example, a criminal matter where it might give rise to civil liability, a person who has been a victim of an injury or a criminal event that may give rise to civil litigation can and should, even before they've hired an attorney, send some sort of communication, whether that's an email or a letter, to the party. That could be an individual, a corporation, or an LLC that is suspected of engaging in negligent conduct, saying, don't get rid of the evidence. Now, I'm going to give you a couple of examples of, and these are very simple, straightforward types of examples, things that we encounter here in this office regularly, and definitely circumstances that I think everybody can understand as being something that might occur. So first off, let's start with a very common, three very common scenarios. So one common scenario where people have a potential to have a spoliation issue come up is where someone becomes injured while they're on the property of another. So These are called premises liability claims, and the most commonplace premises liability claim is when someone slips, trips, or falls on an unsafe condition that they find either on a in a store, for example, in an apartment complex, for example, where they live, or on a sidewalk, either on a private sidewalk or on a municipal area where they trip, fall, and become injured. That's one example. Another example would be one where someone becomes is hurt from a criminal conduct that happens in a hotel. So it may people may or may not know this, but when you're at a hotel, the hotel has an obligation, a duty to its the people who are staying at the hotel, and or their guests, to keep them safe from criminal conduct. And there are certainly a lot of examples of this that one can think of, but certainly that gives rise to liability. Another example still might be what's referred to as a dram shop case. So a dram shop case, that's a case where a bar or restaurant serves too much alcohol to someone who is a patron of that restaurant. And the person then gets in their car, or usually the classic is gets in their car and drives into someone else and injures them, right? So, in any of those three circumstances, there is a very good chance that there is evidence, right? And just to make things simple, the most commonplace type of evidence that you will encounter in those three scenarios is a closed circuit video recording of the event that takes place, right? So someone is in a store, for example, and they slip, trip, or fall on some sort of hazard. And there's a lot of examples one can think of, but milk, some sort of oil, anything that's slick in the store, um, or in the context of something being out on the street or the sidewalk. This could be a pothole or some oil. Certainly, those are a couple of examples. And when you're talking about a hotel, you just say a videotape of the criminal conduct, right? What happened? Um, those are three scenarios, and these are the presence of video cameras are becoming more and more commonplace, just because of digital advances and the availability of that sort of technology. It's not uncommon for there to be videotape of these things. Well, so keeping in mind that spoliation is the intentional destruction of evidence, and the question of whether there's a duty is where the party reasonably anticipates potential litigation, that someone who's hurt or someone who's been the victim of a crime, for example, in a hotel, where there's this sense that there could be a claim against them, or for example, in a parking lot of a apartment complex, any place where you could have a premises liability case and there's cameras, or someone thinks that there's cameras, you can let the party that is going to be a potential defendant in that they should preserve the evidence. You send them a letter or an email, anything that can memorialize your interest in them preserving the evidence, and you've immediately met the standard for the duty attaching to that party. Um, they certainly can't say we didn't reasonably anticipate potential litigation when they've received a letter, an email, or some sort of other, maybe a text message, whatever, any sort of written communication telling them, I'm about to hire an attorney and sue you. So if they've been told, hey, I'm about to hire an attorney and sue you, please don't delete any of the video tape, or the video recordings that you have of this area for such and such a date. That meets that first standard, right? Can they say if there's an email or a letter that they've received saying I'm going to hire an attorney and sue you, or I am an attorney and I'm going to sue you, that you can't anticipate litigation? So destroys one of the defenses that they might have in this context. So you're meeting that standard. So the question might present itself as to like, well, okay, so we have this concept of spoliation. We know that the duty to a party to preserve evidence arises when that party can reasonably anticipate that there's going to be litigation. All right, so what happens if you establish that spoliation has occurred? All right, so well, there's a sanction, right? Just like everything in the law where there is a right, there is a remedy. And the remedy, if there's been a finding of spoliation, is what's called an adverse instruction. This is an adverse instruction to the jury. So, whatever the evidence might be, so in the context of a videotape, it's pretty obvious that the videotape is taping whatever the event is that took place. If you're successful as a litigant in proving spoliation, then you are entitled to an adverse inference instruction. So what that is that the jury will get an instruction from the judge that the defendant in this case was informed that they should preserve the evidence and whatever that might be. So if it's a videotape, could be a bunch of documents. Not sure exactly of the precise scenario, but if it was a scenario where there was evidence that was found in paperwork, anything, let's say maintenance records or things of that nature. If there was a, say, and again, an example of an apartment complex, if they've been told to preserve certain evidence and it's not there, and it's clear that they've destroyed it, right? Then you get this adverse inference. The adverse inference would be in the context of the videotape would be, you jury can assume that the evidence that was destroyed would be harmful to the defendant, right? So that is really fatal for a defendant in a case because it's very difficult for them to claim that make other contentions about what happened, right? So in the context of a store where someone trips, slips, or falls, or in the context of a hotel where someone is a victim of an assault, for example, um, or in the context of an apartment complex where there's some unsafe condition like oil accumulation in the parking lot, or a pothole, or say a faulty railing, or any of those sort of scenarios. If the jury is given an adverse instruction, it does two things. One is it's very difficult for them to say anything about what happened that differs from your client's representation about what happened, because there's already been, there's this instruction that says you can assume that that evidence would have been favorable for the plaintiff. The other part is it makes the defendant in the case look like a real snake, right? So whether or not they destroyed this evidence deliberately or whether it was part of the normal course of things, becomes less important than if you get that instruction, right? So what I'm going to talk about a little bit more is how is it that you determine whether or not that adverse instruction can be given, right? Whether or not the conduct that ended up with the evidence being destroyed warrants a sanction. So let's just start out. We're talking here about Washington State, although my suspicion and my experience as an attorney tells me that in all likelihood that the law is probably not significantly different throughout the United States and also in federal jurisdictions, right? So this is focused on Washington, but again, this is a concept that invariably is pretty well defined consistently throughout the United States. There might be a little bit of variation, but so Washington has adopted a two-part test to determine when spoliation warrants a sanction. The court will, one, evaluate the potential importance or relevance of the missing evidence, and two, evaluate the culpability and fault of the adverse party. Okay, So with regard to the first evaluation of this, they're going to look at is the what is the importance or relevance of the evidence. Now, this is pretty important there because if you think about it, if you get an adverse instruction about some piece of evidence in a case, and the piece of evidence isn't particularly important to the case, an adverse inference is going to make the defendant look bad, even if that evidence is not all that important to the case. I mean, just taking the extreme example, if the video camera is a video camera that didn't have the ability to record any of the events that were relevant to the actual accident that happened, say it's a camera that's pointed at an area where it wasn't involved, simply having the adverse instruction would in and of itself be injurious to that party. So they're probably not going to allow for an adverse instruction in that context. The second the second part of that test is the culpability or fault of the adverse party. So the first question is answered by how important is the deleted evidence. That's sort of self-evident, as I discussed. A video camera, for example, that doesn't look out on the event, that's going to be less important than if it's a videotape that is pointing directly at the event. If the evidence is, say, for example, documents, if the documents themselves that were destroyed are not specifically relevant to the injury producing event, then those are going to be unimportant. So you have to have this determination of relevance. And that's also found in ER 403 anyway, right? So if the evidence is relevant, then it comes in, assuming it's not otherwise evidentiary. There's no other evidentiary issues with that evidence. Evidence must be relevant. That's the basics of evidence. So that's an evaluation that has to take place with regard to any evidence. So the first step with spoliation is this evidence relevant, right? And what is the importance of that? So that's kind of a basic thing that's going to happen in any case for any piece of evidence. The second part is culpability, right? So they're going to, in that second part of this evaluation, they're going to examine whether the party acted in bad faith or in conscious disregard of the importance of the evidence. And an inference of culpability requires a showing that the party knew the evidence was relevant to some issue at trial and that the willful conduct resulted in its loss or destruction. So here we're looking at the conduct of the defendants and whether they did destroy the evidence on purpose, right? But it's a little misleading, right? Because they really don't need to prove, and as we define this a little bit later, in order to get the adverse inference, you don't have to prove that they were truly deliberate in this matter, right? Because, for example, the Washington Supreme Court has held that when a party fails to produce relevant evidence without a satisfactory explanation, the inference which the fact finder may draw is that the evidence would be unfavorable to them. So you can get an adverse instruction if you don't have a very good explanation for why it was destroyed. In other words, if they say, for example, and this is a common, it may or not be true, but commonly when one as an attorney asks for videotape, and if you ask for it too late after the fact, the defendant will say, well, we just tape over that, right? Now, I don't know if that's 100% true, right? But this is why it's very important to get a letter out to the party ASAP saying, don't destroy the evidence, don't destroy the videotapes. I know there's videotapes of this. Because if you send that letter and then they come up and say, well, we just wiped our videotapes clean, um, that may not cut it, right? That's not, you can't just have any explanation like that. You have to have you'd have to have a lot more than just, well, this is just what we do. Now, I think if you're going in 2 to 3 weeks or a month or 2 months out from having sent a letter saying preserve the evidence, um, then you're going to you have a better argument that if you're that party, right? So um, the question of what the instruction is and whether they're going to get have a finding of a spoliation. You can have scenarios where you have gross negligence, um, and that would give you an adverse instruction again. The idea behind the adverse instruction is that the wrongdoer, meaning the party who has destroyed the evidence, doesn't benefit from the fruits of the misconduct, right? So the way that this would all play out in terms of how it would benefit, how you could benefit from this, from some safeguarding on the part of either a party, right? So this would be someone who hasn't hired an attorney yet, or an attorney who is who's involved in representing someone who has been injured. Is that if you, as an attorney, or you, as a party, someone who's become injured or was a victim of a crime, um, if you are, say, for example, in the process of hiring an attorney, or you just are, sometimes it takes a minute to get going. You have the ability to somehow communicate with the party who you think is at fault, and this wouldn't have to be, all that sophisticated of a communication. If somebody has a Google My Business page, you could pretty much go on there and probably say to them something like to that effect. Or if they have a customer complaint email available, you could go ahead and do that. You could also, I mean, if it was as a secondary and not as good as a written communication, if you called and just let them know over the phone. A lot of times, businesses will have processes in place so that they will make a recording of that. You can always go in and say you want to make a report. If you ever make a report, say a supermarket, or um, um, at, at a hotel, like in my example, you can just annotate that report and say, don't destroy any of the videotape, right? It's pretty fair to say that if you're filling out an accident report, or a report of some sort of event that took place at, say, a hotel or something like that, that they're going to know that there's potential for litigation, but you might as well make it explicitly clear. And in the context of an attorney, well, and you want to make sure that as soon as you get that client signed up, as soon as you are retained in a personal injury action, or in some sort of, say it's a dram shop action, or something involving an assault, or some other criminal misconduct in a hotel, or some other thing that would give rise to civil liability, you want to get out a preservation letter, right? And that's one of the things that we do in our office. Anytime we anticipate that there is going to be that kind of information, we send out a preservation letter. And so then later, after the fact, if they've destroyed that evidence, we have that letter. They produce that discovery. They will be most likely subject to an adverse inference instruction. And this is something where, if you have that scenario, that defendants are much, much more likely to want to resolve those cases as opposed to go to trial, because it's just a very difficult instruction to get, because of not just the implications for that particular piece of evidence, but also the shade that it throws on the party, because it makes them look like they're up to no good, which usually they are. So one example of this, of course, as it pertains not to a defendant, but to a plaintiff, um, is something that's come up in a number of my cases, but most acutely in a case a couple of years ago, where there was actually a ruling from the court that my client was going to be the recipient of an adverse instruction is social media. Okay, so we at this office, Herschensohn Law, we always tell our clients to either disable their social media, certainly not to post anything on their social media while they're in litigation or where there's an anticipation of litigation. Um, but that being said, you can't just destroy that information, right? So, given the Wayback Machine on the internet and the persistence of the digital footprint that we leave as we are navigating the internet, setting that aside, there are scenarios where you can lose access to certain aspects of social media. People lose their account credentials, login credentials, things of that nature. Um, and they're unable to get back into it, or they're unable to get into it and have the same level of access. Well, in that context, in particular where the defendant has specifically asked for it, but even notwithstanding that, you can still be subject to an adverse instruction or destroying or otherwise making it impossible for the defense to access your social media accounts, right? And so this happened in the context of a case I was involved in a couple of years back. I feel real confident, given the client, given the guy's character and just the way he was. He was kind of an older guy, and he had been told to preserve his social media account. Um, I don't know that there was really much on the social media account that was really relevant to the case, but there had been what's called written interrogatories that had been sent out to the defendant or to the plaintiff saying, we want to look at your Facebook account and, so on and so forth. And he had apparently either closed out his Facebook account or he'd opened another one. For whatever reason, we could no longer access the social media account. And the defendants brought a motion uh, to get an adverse instruction on that. And they actually were successful. The case kind of resolved otherwise, but they were able to get this instruction. Um, and so I'm just going to read that instruction that the court arrived at. We didn't actually go to trial, so this instruction wasn't given to the jury. But here is the instruction. So you have an example of this on the plaintiff side, and you can flip it around, and it would be similar in on the defense side. So the instruction was plaintiff has failed to preserve a social media account for defendant's use in this litigation after plaintiff's duty to preserve arose. You may, but are not obligated to, infer that the deleted social media account contained posts and or messages that were favorable to the defendant and unfavorable to the plaintiff. Well, this was an injury case, right? So it's not really it's not clear exactly what would have been on the social media page. And of course, what's on social media is usually just a very broad subject matter of all sorts of things, right? And so you can see how if you get that instruction, that it really just casts a pall on the whole party. Makes your client look like there's something on their social media page that's just bad, and it makes them look like they're trying to hide something, right? And knowing this guy, I mean, he just just accidentally. I know he did. He just accidentally deleted his Facebook page. He was an older guy and really didn't have any level of sophistication with regard to um, computers or that sort of thing. So, I mean, I think he was totally innocent in his inability to get access to Facebook. But again, that's you can see how that would really hurt your case if you're a plaintiff. And the flip side is, of course, and the more common is the one where the defendants destroy evidence. And when you know that there is that, that there's that kind of evidence out there, particularly the videotape, it really serves attorneys well and serves the plaintiff themselves, well, the parties who have been hurt, to put that party on notice. Hey, don't destroy this evidence. I know you've got videotape. Don't destroy it. And the same goes for attorneys. If for example you're an attorney who, say you signed the case up, you don't do a lot of personal injury cases, but you decided you wanted to take this case on and you haven't done it before, this is an important thing that you want to do, because if you don't, they destroy the videotape. They can go, well, gee, that's what our practice is. After 2 weeks, we just tape over it, or this kind of thing. So those are the best practices as an attorney, and a good idea if you're a party who's become injured, to get going on that, to send a letter out, send an email, text, otherwise tell that party to preserve the evidence. And if you do that, they either preserve the evidence, which is primarily what you'd like them to do, or you've set the runway for an adverse inference, which, as you could see from that particular inference, that or the adverse inference instruction that was successfully obtained by the defendant in that one case, that could be better than even getting the evidence itself. And I'm aware, more recently we are co-counseled on a case, and there was exactly the scenario, right? Who knows whether they destroyed the evidence on purpose, or if the evidence was really helpful to the plaintiff. But once you get that adverse inference instruction, the jury's wheels are going to turn in their brain. Oh, what was it there? So that's spoliation. That's the concept. That's the legal implications for that. And what I've tried to do is to deliver a little bit of information about how this concept um, and the legal consequences of that can be leveraged to the advantage of the party who's been injured, or in the context of the plaintiff and the defendant, where the defendant can put the plaintiff in a position where they could have a adverse inference instruction. And how can the plaintiff head that off, which is to not destroy their social media posts. So those are the topics that I have for today. Hopefully I'll have more legal concepts to discuss in the future. Again, this is Zach Herschensohn, Herschensohn Law.